Hello. Today, my group and I will be presenting our answer to the assignment question. The question before us is examining how the courts have served as a guardian of fundamental rights through the use of rights-based conception of law within the judicial review process. Allow me to begin by stating the legal justification for judicial review in the accordance with the Senior Courts Act 1981. A declaration or injunction may be made or granted under this paragraph if a judicial review application seeking that remedy is made and the High Court considers these three criteria. First, the sort of remedy that can be provided by mandamus, prohibition, or certiorari. Second, if the nature of the individuals and organizations that may be subject to relief if such directives are implemented. Lastly, the declaration or the injunction of depending on the circumstances would be fair and practical in light of everything that has transpired. Section 31 of the Senior Courts Act 1981 states that one must have sufficient interest in the matter to bring an action of judicial review. In the case of R.V. Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses in 1982, the court listed two stages that have been satisfied in order for judicial review. At first stage, leave to apply for judicial review is only sought after standing has been considered by the courts. This is because, according to Lord Scarman, is to avoid abuse by cranks and busybodies. At the second stage, to reconsider its first decision and reach the conclusion that, all things considered, the petitioners do not have an adequate amount of interest in the subject when the details of the case's merits are understood. The courts use source of powers test to determine whether an entity is private or public. Public bodies with statutory or prerogative functions are subject to judicial examination. If an authority employs contract-granted rights, the matter may not be judicially reviewable. A body's agreed membership prevents it from being exercising public power while it exercises powers. The traditional concept that a public law is institution is one formed by statute or prerogative has numerous limitations. This approach holds that public law bodies are constituted by statute or prerogative. In R.V. Barnsley Metropolitan BC ex parte Hook in 1976, the applicant had challenged the local council's decision to prevent him from trade and remove his right to hold the stall. Natural justice principles were violated, hence he won. Common law grants stallholders access to the market, which can be cancelled for only a reasonable cost and in accordance with the natural justice. In the case of R against Disciplinary Committee of the Jockey Club ex parte Aga Khan in 1993, the court denied Aga Khan's request for judicial review of the Jockey Club's decision to disqualify his winning horse from a race due to failing a drug test. Public authorities are defined in Section 6 of the Human Rights Act 1998 to include courts and tribunals and any individual certain of whose activities are of public nature. Hence, the relationship between racehorse owners and the club, as well as the club's powers, resulted from an agreement between the parties and was governed by private law and not public law. Similarly, in the case of law against National Greyhound Racing Club Limited, NGRC, in 1983, the authority of the stewards of the respondent racing club to impose penalties for rule violations on greyhound owners originates from a contract between the NGRC and the greyhound owners and all those who participated in greyhound racing at NGRC's licensed track. Every license owner and holder is presumed to have read and agreed to abide by the rules. The National Greyhound Racing Club was immune from the judicial review. It was a subject of private law that might be addressed by issuing a summons. There are three prerogative orders under the remedies of judicial review, namely quashing order, mandatory order, and prohibiting order. The quashing order nullifies an unlawful public authority's decision. Decision is null. The prohibiting order can stop a governmental authority from acting unlawfully. Mandatory orders require public authorities to act lawfully. It's requested when a public authority refuses to act. Declaration isn't really a remedy because it has no immediate legal effect. A declaration conveys the court's interpretation of the law on the particular matter and is used to resolve disputes. Interim or final declarations are possible. Injunctions are usually temporary, pending a final judgment, but can be a definitive remedy in some situations. The courts must consider the principles adopted by the European Court of Human Rights, ECTHR, to award compensation when awarding damages. Even though the courts are considered to be public organizations under the Human Rights Act 1998, a court's decision that violates the convention is not subject to a claim for damages. That is all from me. I shall now pass it on to my groupmates that will explain further about our answer. Thank you.
Thank you, Damian. I'm Cindy. Now I'll move on to Judicial Review and Human Rights Act. Before the enactment of the Human Rights Act 1998, the courts have strived to protect the fundamental rights of an individual through the traditional grounds of judicial review, which is the unreasonableness and illegality. The Wednesbury unreasonableness was established in the Wednesbury case, where the focus is on the decision of the public body, whether it is so unreasonable that no one could have conceived the decision. Moreover, the judiciary might declare the decision to be ultra vires, indicating that the decision of the public body exceeds the power conferred to it. Following the enactment of the Human Rights Act 1998, the right-based approach has been developed by the judiciary and is considered to be another way that serves to protect the fundamental rights of the individual. On the conception of the right-based approach, this approach by the courts could empower the judicial review of the administration in accordance with the Human Rights Act 1998. The court's significant emphasis on the citizen's right has given the opportunity for the people to identify those key obligations or unjust laws that will diminish their human rights. By applying the right-based approach, the courts are allowed to challenge any decision which are made by the public authorities which will infringe the people's human rights. As stipulated in the journal article of Legitimacy, Rights and Judicial Review, it was stated that the fundamental rights of the people must have precedence over the ordinary law. In addition, the public bodies will be expected to perform a right-based justice when deciding on any decision that will affect the rights of people. Thus, the public authorities should comply with their own rights and obligations with regards to administrative obligations implemented by the executive. As such, when the courts apply the right-based approach, it prevents discrimination from happening and aims to uphold the rights of the people if there is any infringement of rights under the Human Rights Act 1998. In Regina against Ministry of Defense ex parte Smith, the court held that it was reasonable for homosexuals to be excluded from the recruitment of armed force. At that point of time, the Human Rights Act 1998 was not yet implemented into the local law. In contrary, in Smith and Grady against United Kingdom, the court has discharged the ban when the European Court of Human Rights states that in any cases that there is an interference towards the people's life, it shall be proportionate to the purpose of national security. This clearly shows an impact on how the courts decide applying the right-based approach. The implementation of Human Rights Act 1998 has provided a further ground of judicial review in protecting an individual's rights. So we will look into the test of proportionality now, in which the decisions of the public authorities are to be scrutinized on whether it is compatible with the European Convention Human Rights. For example, in Sunday Times against United Kingdom, the European Court held that the decision of the House of Lords on the interference of freedom of expression must be proportionate to the aim for which it is pursued and must be supported with the necessary and relevant reasons. The application for proportionality provided by the court in the case of R. Daly against Secretary of State for the Home Department, where it was stated that the decision should be made based on the concept of necessity and proportionality, in line with the standards of the European Convention. Furthermore, the Human Rights Act 1998 has allowed the guarantee of fundamental rights by incorporating of the European Convention on Human Rights to the UK domestic laws. For instance, Section 6 Sub 1 of the Human Rights Act 1998 prohibits a public body to act in contrast with the rights guaranteed under the Convention. In this sense, it is arguable that the rights of an individual are protected under the Act. If it is found that there has been a contravention of this provision by the public body, the wrong party may be able to proceed with a judicial review against the public body. Apart from that, the adoption of the proportionality test indicates an extension of the range of options in which an individual may conduct the substantial review of the decision of public bodies. This is beneficial in the sense that the wrong individual is not confined to a narrow scope to seek relief from the wrongful decision of the public bodies. Therefore, it is submitted that by taking into consideration the rights of an individual, the judiciary may be more effective in protecting the fundamental rights of an individual. Now, I'll pass it on to Yisin. Thank you.
Thank you, Emily. When cases related to human rights come into the frame of judicial review, it is often seen that the courts will review decisions with a higher level of scrutiny. This is proven by the standard established by Sir Thomas Bingham regarding the irrationality of human rights cases, which was the more in-depth the intervention of human rights, the more the courts will be bound to justify that the decision is unreasonable, that no reasonable decision maker would have come to it. A term of anxious scrutiny was even introduced and was emphasized by the Lord Justice Buxton that the Secretary of State must fulfill its requirements so as the court in the exercise of judicial review. This is to determine whether the Secretary of State had questioned himself correctly and whether he had exercised anxious scrutiny regarding the facts evaluation. In determining the extent of court application of rights-based conception in judicial review, it is important to look at the implementation of the Venice-Berry unreasonable test in cases of fundamental rights. One of the cases that can be referred to is Regina and Secretary of State for the Home Department ex parte Bryan, 1991, where the reasonableness of the Home Secretary in exercising his discretion to ban the broadcasting of the Irish Republican Army speech is being examined. The court held that such exercise was not unreasonable as the individuals involved were in association with terrorist parties, despite the fact that the discretion might amount to a violation of freedom of expression. Another case is R. Rogers and Swindon NHS Primary Care Trust, where the court ruled that the policy of denying treatment for a patient who does not fall within the category of exceptional conditions, despite having sufficient resources to do so, is an irrational one. Another unofficial ground of judicial review that has been used in many human rights related cases is proportionality. The proportionality test emphasizes that the detriment of an interest under the protection of the European Convention of Human Rights, ECHR, must be proportionate to the legitimate interest either of the community or of the individuals. This test has been increasingly used, especially after the enactment of the Human Rights Act 1998. Because courts are obliged to decide in accordance with the ECHR. The Human Rights Act 1998 enabled the proportionality test to go so far such that it is being used by the courts in imposing limitations on fundamental rights cases involving public safety and national security. A case that can be referred to is the Observer and Guardian at United Kingdom, where the UK government banned the publication of a book in the UK and Australia which contains state secrets. The European Court of Human Rights held that as the book had been published in the US, the publication ban with the aim of keeping the national secret confidential was unproportionate to the right of freedom of expression as stipulated under Article 10 of the ECHR. Another perspective to look into is as stated in R. Razga and Secretary of State for the Home Department 2004 that highlighted the need to strike a fair balance between individual rights and community interests. This is also considered in the case of R. Miranda as Secretary of State for the Home Department to 2014, where his items, which include encrypted materials related to the US National Security Agency, were seized by virtue of Schedule 7 of the Terrorism Act 2000. The court decided that the power exercised by the police is proportionate interference with his freedom of expression as the national security interests outweigh it. As judicial review cases evolve, it seems that courts tend to apply the proportionality test rather than the Venisbury unreasonable test when human rights is concerned. This is because the proportionality test provides a larger scope for the safeguard of human rights. This is evident in the case of R. Daly and Secretary of State for the Home Department, which departed from the Venisbury test and leaned towards the proportionality test. In this case, it was held that the exclusion of prisoners during cell searches and the confidential policy of correspondence between the prisoner and his lawyer were both infringement to the prisoner's right to respect for private and family life under the Human Rights Act. It was also argued that reasonableness is a rather flexible notion as the decision can be more or less reasonable. Meanwhile, proportionality is a very specific part of reasonableness because it is unreasonable to respond disproportionately to a factor or to cause disproportionate harm to an interest that the decision maker should consider. Now, I'll pass it on to Amelia.
Thank you, Isin. Greetings, Dr. Tamara. I'm Amelia. So now let us move on to discuss on how effective the judicial review is on fundamental right cases. To begin, according to Lord Scarman's judgment, in Nottinghamshire County Council as Secretary of State for the Environment 1986, it has been stated that judicial review is a great weapon in the hands of the judges. However, the judges must observe the constitutional limits set up by our parliament system upon their exercise of this beneficial power. First and foremost, the existence of judicial review did necessarily improve good administration. It encouraged administrators and public decision makers to exercise their power in accordance with the law, as they are aware that otherwise they will be subject to review. Indeed, government officials have been issued with the booklet, The Judge Over Your Shoulder, which has been revised to take into account the Human Rights Act 1998 and which remind authorities of their responsibilities under the law. Furthermore, judicial review has actually caused conflict between the courts and the executive over the last 2 decades, as successive ministers of whatever political colors have been subjected to judicial review. In fact, it's arguable that some friction between the 2 branches of the Constitution is actually healthy in democracy, since it indicates that the courts are successfully holding the executive into account and restraining their acts. This is also particularly important in light of the modern executive domination of the legislature. Besides, judicial review claims can be used to highlight a particular issue such as homelessness, prisoners' rights, and so on and so forth. One of the cases which we can be referred to is Rogers against Swindon's NHS Primary Care Trust 2006. In this case, the applicant had been denied certain treatment for breast cancer. She fell within the eligible criteria and the trust did not deny funding on the grounds of financial consideration. However, the trust had developed a policy which denied funding for treatment to any patient who could not show exceptional personal or clinical circumstances. The Court of Appeal ruled that since financial considerations were irrelevant and the trust had the resources to fund any treatment prescribed, to adopt a policy based on individual exceptional circumstances was irrational. However, everything has its pros and cons. Hence, there are also some reasons which question the effectiveness of judicial review. To begin, it's important to bear in mind that judicial review is in essence a procedural remedies in which the courts have traditionally limited themselves to examining the decision-making process rather than the conclusion itself. As a result, judicial review may be a rather observatory in some cases. Although the court may quash the offending decision made by a public body, It will not replace it with another one, but will instead require the body to make the decision again, and this time in compliance with the law, such as by considering relevant factors that were previously ignored. However, this reconsideration could still result in decision makers making the same decision, as it will stand as long as it was made lawfully, rationally, and fairly. An example can be seen in the case Ali against Secretary of State for the Home Department 2003. Lord Justice Godwin granted judicial review of the Secretary of State's decision refusing the claimant leave to remain in the country. He stated, however, that, of course, dependent upon reconsideration on sufficient and proper evidence, the Secretary of State may reach exactly the same decision. Furthermore, some areas of public law decision-making, such as national secretary and national economic consideration, are not susceptible to judicial review, which they are non-justiciable. The remedies available are discretionary and may be denied even though it has been demonstrated that a public body has acted unlawfully. Lastly, judicial review is necessary a reactive jurisdiction in which the ability of the courts to develop administrative principles is subject to claimants initiating actions. As noted by the Democratic Audit of the United Kingdom, in terms of the effectiveness of judicial review, it's clear that the few thousands of judicial review claims made each year are infinitesimal when compared with the millions of decisions taken every year by public body. Hence, it can be said that judicial review is a remedy of last resort to be used when there are no other remedies available. So that's all from my part. Thank you.
The executive tyranny of power is impended. Individuals not only have the power subject action of the government to independent review for legality, but this authority is exercised on the condition that the government abides by the conclusion in its exercise of executive power. Our condition climate is therefore defined by judicial review. It is critical in ensuring that the executive acts exclusively in accordance with the law, and without it, we are on the verge of becoming an authoritarian or even totalitarian regime. We live under the rule of law because of it. For example of exception were cases in which the common law intervened to protect those affected by monopolies or exceptionary rules imposed by trades and profession, thereby making reference to canteen perception, in which the individual in an end in himself, never a mean, only that autonomy give rise from his power of reason, his possession of free will, and the fact that he lived in a society with other of his kind. The autonomy of the will is founded only on reason, and moral laws are based on it, treating a person as a mean, not an intervention of the individual autonomy. Sir John draws a single lesson from such cases: the obligation of the court to shield a person from the effect of arbitrary authority because the common law will not allow the misuse of power. He referred to this idea as a type of benign bias, the technique of making sense of often contradictory values. Furthermore, Sir John stated in spring 1995 article that there is a promise for a judicial review to evolve towards affording clear and systematic protection of constitutional rights. Sir John called concern is the amount to which the ideal basic right ought in principle to alter the rich underlying of democratic authority, which is another way of looking at the link between the law and democracy, between judicial power and parliamentary sovereignty. He does so by referring to the freedom of expression. Moving forward to the critics. Sir John, on the other hand, considered that the incorporated ECHR lacks moral sovereignty and is nothing more than a further amendment in the losses of moral against injustice and abuse of power. Burton's most famous attack was against the concept of extra-large natural rights. However, no foundation for Sir John to distinguish between basic and natural right. As a result, we have a Human Rights Act that specifies legal rules. Nevertheless, the including provisions are so open texture that the court will be focused to exercise their political judgmental in the process of interpretation considerably more broadly than before. Sir John acknowledged that the integrated provision of the convention are worded in rather broad language, but finds that the brief of a strictly legal right will be determined by UK judges. Sir John argues that when UK court interpret convention right, they will adopt the Starbuck Convention, which allowed government to restrict rights where they are essential in a democratic society, defined as representative basic social needs. Nonetheless, as he points out, one person's present social need is another's person's cohesive interference with fundamental rights, while due process rights are largely unassailable. More substantive rights are defensible in the public interest. Aside from due process, where should the line be drawn between excessive activity by judges and a failure to preserve constitutional rights? Sir John cited Lord Beckham's statement in Ex parte Smith, where the appellant lost their claim that they were wrongfully discharged from the military forces due to their homosexuality. The court may not interfere with the implementation of an administrative decision on substantive ground unless it is satisfied that the decision is irrational in the sense that it goes beyond the range of acts available to a reasonable decision maker has surpassed this margin of apprehension. The greater the interference with human rights, the more reasoning the court will seek before it convicts that the decision is reasonable in the sense mentioned earlier. However, furthermore, Sir John thinks that the idea of proportional will be mediated by the UK courts to bridge the gap between the Wednesbury and the test of present societal necessity. He acknowledged, however, that in Britain, Lord Ackner and Loring both dismissed proportionality as a potential benchmark of the legitimacy action, arguing that it signified a departure from Wednesbury and required the court to redecide the merits. Sir John responded by stating that this is no longer the law. When a basic right is an issue, the court will assume that it must be given high priority and will require the decision maker to present a significant objective justification as he is to be permitted to overrule it. Using the proportionality principle in this manner caused no offense to democratic power claim. As we have seen, one line of thought holds that the Convention right and therefore the Human Rights Act should be seen as a living instrument whose concerns are meditated by court in line of charging social situation and philosophies. Sir John appreciated that and clarified that it does not imply that judges are being asked to establish policy. Rather, it indicates that judicial administration of the convention is more akin to the progressive evaluation of common law than the construction of legislative provision in domestic terms. That is all from me. Thank you.
In the judicial review process, according to the Human Rights Act 1998, Section 3, it requires all courts and tribunals to interpret all legislation so far as possible in a way which is compatible with the Convention rights. Furthermore, before the Human Rights Act 1998, the courts protected the fundamental rights by using two traditional grounds, which are unreasonableness and illegality. However, after Human Rights Act 1998 was established, the right-based conception of law has been applied by the courts as another ground that is utilized to protect the fundamental rights of the individual. Until this day, the proportionality test is still the main determinant being used for judicial review in regards to cases related to human rights, sometimes along with the Wednesbury unreasonableness test. Nevertheless, court will need to clearly lay down the elements and the role each element plays in this case such that it may provide greater analytical clarity when it comes to the human rights cases. When all is said and done, the facts remain that judicial review has proved to be a useful and effective instrument for protecting human rights. So that's the end of our presentation. Thank you.